This is Kathleen Bonzik, and the following is a primer on contracts. What is a contract? A contract is a meeting of the minds or an agreement between two or more parties or entities. And the subject of the contract can be goods or services. And in exchange, something of value is given. The legal term is consideration. An example for a contract for a good is as follows. Party A agrees to sell a used vehicle to Party B. In exchange for this good, Party B agrees to pay Party A $6,000 for that vehicle. A contract for a service might be as follows. The Zippy Printer Company agrees to fix Party D's home printer which keeps jamming. In exchange for this service, Party D agrees to pay the company $40. Offer and acceptance is important in contract law. Generally, a valid contract exists at the moment when an offer is accepted. For instance, suppose you agree to pay someone $50 for her used sofa, and you shake hands to seal the deal. Although the furniture and money have not yet been exchanged, meaning the contract is not yet complete, a meeting of the minds and hence a valid contract is in existence. The other party would be in breach if she reneges on your deal because someone offers to pay her $75 for that same sofa 2 minutes later. Verbal contracts. Many contracts are in writing, but is a verbal contract valid and enforceable? With a few exceptions, the answer is yes. Refer to your state's law known as the Statute of Frauds for further information regarding the types of contracts which must be reduced to writing in order to be enforceable. The purpose of a statute of frauds is to prevent just that, to prevent fraudulent claims from arising from non-written verbal agreements. Now, these laws vary from state to state, but the most common types of contracts that must be in writing typically include contracts for the sale of real property, a promise to pay someone else's debt obligations, or a contract that will take more than a year to satisfy. What is a breach? A breach occurs if one of the parties to the contract refuses or fails to live up to his or her side of the bargain. If one side does so, there is a breach of the contract and certain remedies for solving the differences between the parties are available in court. This is Kathleen Bonzik. Thank you for listening.